While this episode of Life, Loss and Legacy is meant to help you learn and educate yourself around some of the topics discussed, it is worth noting that all opinions and information provided are the opinions of the individual speaker and do not represent the opinions or thoughts or perspectives of any other party. I also want to emphasise that the information contained in here is very general in nature, and it is vitally important that before you make any decisions about what to do in your current estate situation or following that, be sure to obtain personal professional advice. We do not know your current circumstances, so please do not act based on what we talk about in this episode. Be sure to get that extra advice. All right, that's enough warnings. Let's get into the episode. Thank you very much. Hello and welcome back to Life, Loss and Legacy, the podcast for people navigating those first few years after losing their partner. My name's Jordan Varker and I'm from Planning Solo. I'm an independent financial advisor who specialises in helping people through those first years. And I'm joined today by special guest Lucy Percy of Head and Heart Estate Planning. Hello, Lucy.
Hi, Jordan. How are you?
I'm very well, thank you. I'm very well. And I've asked Lucy to join us today to discuss estate planning, wills, beneficiaries, and documents. And in doing so, obviously, Lucy is an expert in this space. She's the founder and principal lawyer of Head and Heart Estate Planning, and she's helped quite a few of my clients lay out the documents that they need to make sure their wishes are carried out. So, Lucy, thanks for joining us. Let's start a little bit with, let's hop straight into it. Let's start with a little bit of a background on estates, if we can. Specifically, where are the three areas that lawyers can really help with people in that period of planning what happens at the end?
Yeah, absolutely. So in terms of planning, you're right. What we start with is what's the outcome you want to achieve? And then we reverse engineer it. We're like, okay, well, to achieve that outcome, you're going to need to do this, this, and this in terms of your legal documents. So in an estate plan, that is typically, I say, we want documents that are going to operate in your lifetime and on your death. That's a really key distinction. And we also need to do planning for your assets that are going to fall inside your estate and outside your estate. So a lot of people don't actually realise that your will can't gift everything that you own. There are certain asset types that your will just isn't going to have jurisdiction over. So I say before death and after death, inside and outside your estate are the key things that I say to people when we're planning.
And that's the planning aspect, and we'll cover in other episodes the administration and the disputes piece of estates. But with the planning side of it, I guess one thing that I'm keen to find a little bit more about, and most of the people that are listening have probably been through part of the process, but why is it so valuable for people to have an estate plan in place?
Yeah, I mean, we can look at this in two ways. We can look at estate planning as bringing us closer to the things we want. So that could be leaving a legacy that, outlines our values and really, is a continuing last act of love for the people that we want to take care of on this earth. It can bring us control. Yeah, it can bring us control. They're all the things that we're moving towards. But the other way to look at it is it's so valuable because it helps us move away from the awful experience after probate when something might be going wrong. So that could be we're moving away from uncertainty, conflict, time delays, expensive legal fees. So I always think of it in two ways. It's bringing closer to the things we want to achieve for the people we love, and we're also pushing away the things that we would never, ever knowingly want to leave people with that kind of mess.
I like that perspective because I think most people's vision of an estate is that negative, is what do I want to avoid? I don't want to have that big argument that happens after I'm gone. But it can be, I think you mentioned it's the last act of love for the people you leave behind, giving them that roadmap of how you wanted things to play out. Hopefully that helps some people, encourage some people to get this plan in place, because a lot of people avoid it. So I am curious, who do you think should be doing an estate plan?
I mean, the textbook answer is anybody over 18. So even if you are a young adult and you don't have any assets, we always have, usually by that age, super, with typically a portion of life insurance inside it. The super rules, and I know that you will cover this in another episode, about who we can pay our super benefits to are really quite strict. So if we have a young adult who's 21, has a portion of $200,000 or $300,000 cover in their super, they might say, I don't have anything to gift. Why would I do a will? Well, the answer is you can't nominate your parents or your siblings as beneficiaries of your super. So you want to make that easy for them. You might also be in a domestic relationship at that stage. And so, if something happens to you, there'll be some uncertainty, some conflict. I certainly hear about these cases at least once or twice a year where a young adult has died. You might say, I don't have much. What you've got is going to pay for your mum to take a year off work to grieve, So sometimes even the less we have, the more impact it's going to have for the people around us when we're gone. So who are we to say that 100 grand isn't much? If you're the person suffering that grief and loss, 100 grand could be life-changing in terms of really letting you take care of yourself. So, for parents with young adult children, sometimes I say, I'm thinking of a beautiful woman and she had a daughter going off to be an au pair, and I said, I'm just going to do this for free. Like, I care so much about your daughter having proper documents. And if I didn't believe in it, I wouldn't do those freebies.
Yeah.
Do you know what I mean? Like, if that's a measure of how much I believe in it, there every now and then I'm like, oh, that young adult is, high risk. Let me help take care of that. Or we bundle it into the parents package and do something pretty basic. So young adults, obviously then you've got your other commencement triggers, or, we've got when we increase insurance, when we have a relationship, so that could be marriage or it might not. You might also touch on this in the super legislation, that length of a relationship and what it looks like to make a claim under a will or intestacy versus under super is actually different. They're different thresholds. So, starting a relationship. Marriage, definitely marriage revokes previous wills. So that's at operation of law. Divorce, and buying a property, having a child is a key one. With the buying a property, I always say to people, please come to me first. Like, don't let your conveyancer tell you how to own your property. Joint proprietors, tenants in common. And it has such a critical impact on the end game on your estate. Come and see me before,
That's interesting, because we will have an episode with a buyer's advocate and a finance broker about buying that first house on your own. So just to emphasize that point, get proper advice around how that should be structured.
Totally. So sometimes I'll do a discovery call and clients will be like, okay, we're just finishing this settlement and then we're going to be ready to start after it. And I say, actually, can I put my hand up? Can we do a free half hour even? And I just want to talk to you about your ownership options, because it's not uncommon for me as part of my estate planning, and especially with blended families, to actually ask clients to change the way they own their home. So get that advice early and you'll save us having to restructure it. If it's an investment, we will not be able to change the manner of holding without paying stamp duty. So please get the advice early. It is fatal in terms of the end game, when you die.
And I think that's a crucial lesson for all of this, for anybody listening, is getting the advice early saves you a fortune compared to trying to fix things after it's done. So we're working on one at the moment where we're trying to retroactively fix some things, and it's a real mess. So get the advice early, get good advice as quickly as you can. Lucy, what about business owners? How does that, are they people that, how do they document things?
Yeah, that is a great question. Obviously, it's a passion of mine because I'm a business owner, and my husband has had, a business before. We are just self-employed business people, and the responsibility and risk that you have is, not heavy. What do I want to say? Fulsome. So it depends on the way that you're structured. If you're a sole trader versus in a partnership, I don't see too many of them anymore, versus you have a company or a company owned via a trust. So my answer to that is going to depend on those things. But the key thing to understand is that you've got your will, and your will is going to appoint a personal executor. I'm going to use my structure as an example. My will only let me gift the shares in my company, okay? And then the recipient of those gifted shares, so let's say that's my husband, is going to vote in a successor director of my company. So if we have mum and dad and they have a company worth $5 million, let's say it's all in dad's name, and his will gifts his shares in the company equally between his 3 children, we're going to end up with a situation where 2 of those children could form a voting bloc against the third. They could vote themselves in as director, and the third child could be left out. So there's lots of great things we can do there. You can change the constitution of a company that says, appointing a successor director to Lucy Percy requires an absolute majority, a special majority, something over 50%. So for blended families, self-managed super funds with corporate trustees, this comes up a lot. But yeah, really the key thing to understand is your personal power of attorney will not let your personal financial attorney stand in your shoes as director. Your will not let your executor stand in your shoes as director, if we're talking about company structure. They're going to stand in your shoes as shareholder, and then that person as shareholder is going to vote in the next controller of the company. Is that helpful?
Absolutely. And I think that's a really key point. And there's probably one that if people wanted more detail on, contact Lucy, I think, because again, a lot of the people
on it.
I imagine a lot of people listening to this have been through something. They've, their late partner owned a company. They've had to deal with that kind of, there's not a tussle, but it's an administrative wrangle they have to go through. So if you are in the middle of that, or if you've navigated through that, please, reach out to Lucy and have a chat. Because
Oh, I was going to say one last thing that I will add, though, is a very valuable document is a company power of attorney. So your personal power of attorney can't do those things. Your company as an entity can have a power of attorney. In terms of the cost, like let's say it's $550, the benefit and the security that you're giving yourself is just, the value of that is just exponential. So what that means is that if a director loses capacity, while their personal attorney is going to seek changing the directorship, or maybe they decide not to, the company won't cease trading. So we can still contract, we can still call in money, we can still pay wages, we can pay rent, we can collect rent. If we don't have a company power of attorney and there is a death or an incapacity, there is going to be a lag that is going to have a severe consequence on a trading entity.
If nothing else at all.
Yeah. There are emergency things we can do at court. Maybe some of your audience will have had to do those, like rush off to court and get a limited probate just to pay wages or do something like that. But you really want to avoid that. And for a very simple document, you can.
Yeah. And I think we're talking about estate planning. And I think for a lot of people maybe that haven't been through the process, that translates into will. But even as hearing you speak, Lucy, there's so many other documents, there's so many other things in place. And one of the things that I initially found almost frustrating about working in the estate space, now I think it's fantastic. There is no right solution.
Yes.
You mentioned earlier that it's about identifying the goal of the objective and then building it around that. Feels like every path is possible, but every path has a consequence. And that's why working
such a great way to put it. Yeah.
Working with an expert, I think, would really help you with that. Which brings me to my next point. There's three main ways I can think of, 3 or 4 main ways that you can draft your quote unquote estate plan. Can you walk us through, probably from in order of least effective to most effective, your different options for drafting that estate planning paperwork?
Okay, so the first one is probably my biggest competitor in business, and it is people who choose to do nothing. Just apathy, overwhelm. I'm going to do nothing about this. So I'm not worried about all the other wills and estates companies. We know that up to 75% of Australians just don't have anything in place or have very old documents. So in terms of how effective is that, it's awful. It's terrible. You don't want that to be your legacy. So that is what we call dying intestate, where you die without a will in place at all. And it can increase time delays, complexity. It means you have zero control over who's controlling your estate. And the court can put complex conditions on that probate. So, if I can touch on one, an example would be that if I died without a will and I had children to my current husband, but I had children to a former spouse, the court isn't going to release all of the money to my husband. They need to assign a portion to the children from another relationship, but they might ask for what's called a surety guarantee, or they probably will ask for it. So that means the amount of money going to my children, not of my relationship with Nick, they would say, okay, that's $400,000. Someone needs to put $400,000 surety up to the court, so that if the administrator runs away with that money, the children have a recourse to get it back. So think of it as bail. When Tony Mockbell skipped town and went to Greece, it was his sister-in-law or someone put up $1 million bail surety is the exact same thing, but in the estate space. So it's not just where there's minor children, the court can demand a surety over a certain amount of money. And I had a case 2 years ago where the administrator just couldn't come up with the surety. She was an aged care pensioner, no assets, and we were just stuck in this vortex of...
So it's actual cash. It's not a personal guarantee. They have to stump up the actual cash or assets.
It's a guarantee, but she didn't have the assets. And
would so the guarantee wasn't worth anything.
Well, yeah, but also, would I want to stump up a guarantee? Not really. Like, no.
And those calculations in that, there's no discretion around there, is there, within intestacy?
Well, all of the beneficiaries can consent to dispensing with the requirement for surety guarantee.
Oh, God. But everybody has to.
Yeah, and the beneficiaries have to have the ability to consent. So if we have minor children, maybe their parent or their guardian just wouldn't consent to it. You know, like, why would you consent to dispensing with the requirement? You don't know that the money's going to, you're not in charge of the money for them. So, but again, it's just an example of something that can blindside families. Like, you think you've had the worst thing happen to you, and then you think common sense will prevail. Actually, the law and the court system has all of these rules that are designed to protect us, but they're really complex and they add a lot of delay and a lot of cost.
So here I am thinking that one of the worst things about intestacy is that your estate is divided according to a formula. Like it goes, doesn't it? Like that, and that's different across the country. I think each state has it's all different. This surety idea makes it even worse. That's horrendous. So intestacy is your biggest competitor and the biggest danger, I think, to most people's financial future after passing away. So please avoid intestacy. Get a will done.
Yes.
What are we doing?
Post office will kit.
That's the next along the spectrum,
next
isn't it?
one. Yeah, I'm going to deal with post office will kit together with, it's probably a new phenomenon, but the online law firms. Some of them are law firms, but then they'll have a disclaimer, we're not giving legal advice in these documents. They might say the wills are lawyer checked or written by a lawyer. Unless you've got strategy advice from a lawyer, the written by a lawyer is meaningless. Like, I could write a template and sell it, but you know what? If I believed in these documents, I would release a product myself, but I just don't believe in them.
I think already you've covered so much nuance, and we've only been talking for a little while. To have an off-the-shelf solution feels a bit limiting. But so we've got post office, an online quote unquote law firm.
Yeah.
What are some of the issues that can pop up?
Yeah, post office will kit, very simply, we see them filled out incorrectly. So the law societies in Vic and New South Wales is where I'm most comfortable talking about. They do count the statistics about where these things go wrong, or they also count the statistics about where lawyers get wills wrong and are sued the most commonly. And I'll actually tell you that later because it explains why you need an expert. But a post office will kit, so people can fill it out incorrectly. One example could be, and this is the most common with DIY, people might gift specific things. I give my car to, I give my house to, but they don't have residue gifting. So the gifting of the residue of your estate is the most critical gift in the will. It's actually surprising. Sometimes when I do my wills, I say to people, was it anything you thought we'd talk about that we didn't? And, have we not covered anything? And they say, no, I'm just so shocked about how general it is. Like, we haven't named anything. And I say, yeah, because you're going to get the most flexibility, the most longevity. Like, gifting your car doesn't matter. Like, it might to some people, but the residue is the most important bit. So that is, we call in all of your estate, and they're your assets. We pay all of your liabilities, they're your debts, and then we're left with what's called the residue. And your residue clause should be written in parts or shares or percentages. So we don't know what your residue is going to be. So I'm not going to give 500,000 to one person. We don't talk in numbers, we talk in percentages. DIY will kits really often miss out on that because the general public isn't thinking about the residue, they're thinking about what do I own today. And if you sell your house or, your bank account closes or your super fund moves, then those gifts are going to fail. So you can have partial intestacy where we've got some of a will, but it fails to appoint an executor or it fails to gift the residue. And then you've got to go along to court and you get letters of administration with the will annexed. So we're going to use the will to the maximum capacity we can, but the rest of it is going to be called intestacy. Does that make sense?
It does. I mean, it kind of boggles the mind, to be honest, but because we'll talk a little bit about what makes a will valid, because it's very specific requirements. But I'd never thought of the residue element, the fact that
Oh,
the
yeah.
specificity in a will can actually be to your detriment in the longer term.
Correct. It can be your undoing. Yeah. The one thing I love about post office wills, only compared to intestacy, I mean, at least you're usually choosing an executor. That's
Mm.
hugely important. Typically, post office wills, DIYs don't have enough layers. So when people work with me, I'm always like, what happens if they die? What happens if they die? What happens if they resign? So we're missing the layers. But the one thing I like about them compared to the online will solutions is the people are limited by the space on the paper. So you can only muck it up insofar as you can fit the words in. With the online wills, I saw one that was 14 pages long, and this person had just kept typing these gifts, and the will maker platform didn't cut them off. And it was just 14 pages of nonsense and absolute
Like really
legal.
specific
Oh, it was
individual.
chaos. Like, I gift a nice amount for this person to put into their super to enjoy their retirement. And I was like, number one, super's not an estate asset. Number two, what is a nice amount? Like, they double gifted things. This person had done a 14-page will, included all of the beautiful people they love in their life. What they didn't realize was they don't have a cent to their name. All of their assets are owned in a trust that their dad left them. This person,
Oh,
their
wow.
estate will be zero. They need to do succession planning of the trust. And this was 4 years on, 3 conversations in, and they said, oh, I've got a will. Oh, can I have a look? And I just thought that just the pages and pages of badly drafted gifting. And I just thought at least the post office wills cut people off. Like,
Mm. Yeah, it limits the rolling mistake they can make.
it limits it. I was just like, oh, goodness me.
And I think, I mean, historically, I've always been very tight, so I always thought you could DIY a lot of things, and I have a long legacy of mistakes that have come with that. So I'm very much of the mindset now, if you're going to do something that's important, get an expert to help you. Whereas these systems, I mean, the post office one better, but the online system, they're not going to prevent you from, cutting your own foot off, basically.
No, no, absolutely not. And they have no interest in doing that. They might, who knows,
Well, they're not
they could
providing
be owned by
advice.
firms that do litigation, or, who knows. And I'm not, that is not a declaration. I haven't looked at the ownership of them, but certainly some of them are true law firms. They just exclude themselves from giving advice.
Mm.
I'm going to explain the statistic about where do lawyers get wills wrong is going to help you understand why you need advice.
Yeah,
So
okay.
filling out those forms. In Victoria, lawyers get sued on estate planning for the greatest simple fact that they haven't checked how their clients own their property. So a lawyer takes instructions, writes a great will, and they've failed to check, is it owned by the testator at all? Like, people honestly sometimes think they own something and they don't.
Mm.
Or like, like the other fellow, it could be owned in a trust or it could be owned by the partner. Or they own it jointly, which means if you own something jointly with another person, the Wills Act, you can gift it in your will, the Property Law Act is going to trump it. And so the Property Law Act says anything owned jointly will pass to the survivor outside the estate of the will maker. It
Mm.
is not an estate asset. Or do you own it as tenants in common, which means the percent that you own is discrete from the other owners and it will be able to be gifted in your estate. So where lawyers are going wrong is they're taking instructions, I want to gift my house this way, but they're not stopping and checking the source document. How does the client own it? The death occurs, and then in the administration phase, there's a surprise, they don't own that property, or surprise, it's actually owned tenants in common, and now the other owner is going to force a sale on the widow or whatever. And so that's where lawyers are getting sued. So that should hopefully explain we're not just taking instructions and writing a document. You need our strategy advice. That's actually what I sell. I sell strategy, and then we put it in the documents. So,
And
I just...
it's something we come up it's kind of been an evolution in advice for us as well, is not taking things at face value so much anymore, but getting those primary and source documents. And it adds a lot of friction to the process because we're collecting a lot more
Mm.
data and information. That has privacy and security issues and all that. But we
It's
need that to make
tedious.
sure the advice reflects your actual circumstances, not
Correct.
your understanding. And I
Yeah.
think I just realized as we're talking, this may be triggering quite a few of the people that are listening because they may have had some of the negative outcomes of maybe bad
Mm.
strategic planning or bad documentation or outdated documentation. Um,
Mm.
so we might move on to kind of the best end of the spectrum of documenting your estate plan. But I think there's two sub areas there. There's really getting advice from a lawyer, but then there's
Mm.
kind of getting advice from a general lawyer and getting advice from an expert lawyer. Can you walk us
Mm.
through maybe the distinctions there?
Yeah, I mean, people often ask me, why are your prices? My mum got their will done for $500. Like, can you talk to me about your pricing? And I do not mind that question at all.
Mm,
So, historically, wills have been what we call a loss leader product in the legal service industry. So, a loss leader is when we sell something at a loss because we know it's going to bring in other work. So, family law, I want to grab a wills client because when they divorce, I'm going to make 50 grand from them. I'm
mm,
going to grab a wills client for $300 because when there's a death, I'm going to charge 20 grand in the probate. And maybe if there's a litigation aspect to the file, 100 grand. So
mm,
that's how people have been funding wills chapters of their firm, I suppose. The issue with a generalist law firm, I suppose, or choosing not to use an expert is that I think that wills and estates is a great area. I love it because it touches on every other area of law. It intersects with property law, Corporations Act, family law, like you name it. If you die and you've got other legal things going on, we're going to have to work and, put it all together for you. So it's
mm,
so interesting. But what that means is that the complexity these days is astronomical.
mm,
So I honestly don't believe that to do the best job by your clients, you can do this area of law and much else. Maybe you could do one or two,
mm.
but the volume of, I don't know, professional development and things that you just need to know. I mean, you would find that as a planner. It can't be a side gig. Wills and estates is not a side hustle to your main law firm business.
I think it surprises me to hear that that is kind of a topic in law because I always think law has those very specialist silos. But you're right, you do have those general firms that are,
Mm,
typically out in the suburbs. They a bit of a one-stop shop, and I think there's a valuable service there. But yeah, you're right. In planning, the complexity is too great now. I
mm,
I feel it adds too much of a risk to the practitioner and also to the client to
mm,
say, well, I reckon I can do this, but realistically, maybe you're at 80% of the
mm.
complexity or 70%. There's a huge gap there. And I think with wills, you won't realize that something's gone wrong until a very, very awful time far down the track.
Yeah, correct.
Um,
Yeah. There's no one capturing your mistakes. That's right. It'll be when the death occurs and then you realize, oh, my precedent was out of date, or oh, I didn't realize that happened, you know. So,
so if we're working along that spectrum, intestacy is the worst. Post office wills are a bit better. Online wills are in that same bracket. A will from a general lawyer could be good. It's better than the other
yeah,
options. But then we're dealing with an expert, and why is that worth doing?
yeah. Well, it's a great investment. The saying that comes to mind is the poor man pays twice. So
Mm,
you can pay me my fee, and I'm going to give you genuinely the best document that you could have. Whether you have a $400,000 estate or a $20 million estate, the bones of what I'm going to use for you are going to be the same. My approach, my service is going to be the same. We're going to do the best job we can for everyone. We're going to give you a plan that gives you your people certainty. It's not just going to work on paper. We're going to talk deeply about your relationships and the relationships of the people you're appointing. So we say, this is a great plan. Is it going to work in reality? Tell me about those people. Are they, generous or stingy? Are they going to listen to an accountant when they tell us how to do something? Are they going to be proactive? Have they done their own tax returns on time? So we're stress tested in terms of legal strategy, the relationships. It's going to be the most tax effective that you can achieve. So there are some things that we put in people's wills, and even the planners or the accountants, when we send a copy off, they say, "Wow, I didn't know you could do that." And I'm like, if the will or the estate planning pays for itself in even just one clause, which it might. Or for me, I actually always say to people, my power of attorney is probably going to pay for itself in terms of like the bespoke powers and conditions that we're going to include. So when you think about, you know, the cost difference between a general law firm and a specialist or an expert, it's actually not huge. Like, it's not like we're talking about buying a Holden Berliner versus a, you know, I don't know, an expensive
Mercedes.
car. I'm not a car person. But do you know what I mean? Like, the difference is just not that big.
Yeah.
But the difference in outcome is going to be exponential. So
it's that idea of certainty for you and for the people you're leaving behind. You can feel a bit more confident in that documentation. And I think as you're speaking, I mean, an analogy that keeps popping up in our world is the difference between kind of buying a mass market home and an architect home. Like,
correct.
the architecturally designed one, it's a lot dearer. So it's not a perfect analogy, but it's going to be far more tailored to your situation, to the site, to what you're looking for. Exactly. And it's far more valuable, I think, for the people that value that. So I think I would encourage it. And the description of your process that you've gone through there, I get to hear the stories of other people's experiences, and that is not the experience people have with a generalist firm or a post office will. Post office will, it's very lonely, it's all on their shoulders. A generalist firm, people often feel rushed. They can feel like they're getting squeezed through a sausage maker. But yours is very, very deliberate, very methodical, very, you're not rushing people.
It's
when they're
high
ready.
touch.
Yes.
It's high touch. So, and the other thing that I think is different is when a generalist law firm, if you don't have the skills to change the document. So, you know, I appoint Jordan and Lucy as my executors, and then the backup is I appoint Nathan. Does Nathan come and join Lucy if Jordan can't act? Does he join Jordan if Lucy can't act? Like, if you have an expert, we can draft any combination and the words are going to be subtly different. If you have someone who doesn't have that drafting skill, they're going to be like layer 1, Lucy and Jordan, layer 2, Nathan. And, you know, we can just offer so much more choice, and it is so bespoke. And it might not sound important, but when you get to the administration phase, all of those little triggers that we've, you know, touched and pulled and worked with really carefully, all the strings we've pulled are hopefully going to make for a better outcome. All I want is for people experiencing loss to have a clear pathway forward that works on paper and works with the relationships.
It sounds like that difference between constructive ambiguity, like giving them flexibility, and destructive ambiguity where people are left wondering. The metaphor we always use internally is people are walking through this tunnel. There's a light at the end of the tunnel, but they're walking through the tunnel. So good documentation should shorten that tunnel for people and make that journey a little bit shorter for them. I want to talk a little bit about how we can bring more urgency to people getting their wills done. But before we do, I realise we're using maybe some jargon and some bits and pieces here that people may not be comfortable with. So if I throw a few words at you, if you don't mind throwing out some definitions. Firstly, power of attorney in very broad sweeping terms. What is a power of attorney?
Okay, so it's a document that operates while you're alive. It ceases to have effect when you die, and it appoints someone, your attorney is the person's name, to stand in your shoes, and they manage your rights and responsibilities on this earth when you can't do that yourself. So you've lost capacity. One distinction I'll make with power of attorney is the trick is with a will, you know, the similar person in your will is called your executor. With a will, we've got stable ground. The worst thing has happened. The death has occurred. We're dealing with stable ground. With a power of attorney, it needs to work if you're hit by a bus and you're in ICU for a week and then you die, or you might have a stroke and you live for 20 years after that with incapacity, or you have dementia for 15 years. So that's the trick there. That's why I say, you know, your power of attorney might pay for itself. It's as important as the will. Yeah, sometimes even trickier.
And branches out into different areas, financial, medical. It doesn't cover health directives. That's something you do with your GP, isn't it?
Yes. Well, so that's it chooses the people who are going to make healthcare decisions. If you want to give them a binding list of health decisions you would have made, that's your GP with an advanced care directive. Yeah.
Can you describe fairly quickly, like, you know, broadly, what's an executor?
Yeah, an executor is the same thing. I say on your death, your executor's rights and responsibilities are enlivened. So that's even before they go and get probate. At law, they are meant to be operating as your executor. If there's two wills or we don't know who it is, that's difficult. They stand in your shoes and they are responsible for your responsibilities. So keeping your property insured, maintaining your dependents, all your legal compliance and aspects, and they are responsible for your liabilities and the things that you owe to other people, I suppose. So they have the legal power that you had when you die, but then there's lots of limits in that. So they need to have good executive powers. The executor is really given its power in the will, but then the court confirms it by giving a piece of paper called a grant of probate. So the executor takes the will to court and says, I think this is the last true will of the deceased. I think it's legally valid. What do you think? The court inspects it, looks at the affidavit, and then if they agree, they give the executor a piece of paper called a grant of probate. And that is the executor's proof to the rest of the world that they have the legal standing to make those decisions that the deceased could have made or to wind up their estate.
Thank you. You've preempted my next question around probate.
Okay.
So that's perfect. And we will have another episode exploring the executor duties, but it's a very important role. And now my understanding is that they're standing in for the deceased. They're not making the decisions based on the executor's thoughts. They're trying to execute the deceased wishes. That's their responsibility. Is that right? Correct.
So the executor shouldn't have too much discretion. They are meant to follow what is in the will. So when there's litigation, for example, it's not about the executor thinking, well, the deceased should have given X, Y, Z that. I did actually have a case where the sister-in-law, the sister of the deceased, was the executor. And again, it was a problem that happened with joint ownership versus tenants in common. If you have 2 minutes, I'll tell the story.
Yes.
There was de facto partners. They were engaged. They had been together for 20 years. They both had a child from a previous relationship. They got together when each of the children were about 1 or 2. They had separate houses and they'd paid off their mortgages. And then when the kids were grown up, they said, we're going to sell your house and we're going to buy a family home together. So he kept his home as an investment property. She sold her house. Let's say it was worth 2 mil in Melbourne. And they used her 2 mil to buy a new family home for both of them. Instead of getting legal advice about how they should own the property, the conveyancer ticked joint proprietors, okay? No, tenants in common. And so the conveyancer immediately gave him half of her equity. And she didn't get independent legal advice, so she didn't sort of really realise what was happening. He then died 12 months later, and his half of the house went to his daughter. The daughter did evict my client, the stepmom. It was awful. So the deceased sister was the executor, and she was like, this is not what he would have wanted, and was acting in a way that really substituted her judgment for what the will said and what she thought was morally right. And she got removed. She was successfully removed because it's not what you think, sister-in-law. Morally, you're on the right track. But actually the will says we have to do this, this and this, and it has to go to the daughter, and you don't have the authority to substitute your judgment for what the will says. And if you can't enforce the will and carry it out, you'll be removed. And she was. So that's a really great example, I suppose, to, explain sometimes when people think, sometimes people say, oh, the will's going to be contested. Should I be executor? And I'm like, absolutely, because your job is to uphold it. If you don't, if you're not an executor, then you're really going to have 3 parties, you as the beneficiary, the executor defending it, and then the claimant. We might as well, lots of reasons why we wouldn't. But I'm like, let's cut it down to 2. Like, you're going to have to defend it anyway.
We'll expand on beneficiaries in a sec, but let's go to the big document. I guess the core part of any estate plan is the will. Can you walk us through, even just really basically, what is a will?
Yeah. So a will it should be in writing, but there are case law about informal wills that are, a video or voicemail. I'm not even going to touch on them because you should just go and do the proper thing. So it should be in writing, and it has to have a few key elements. So the person writing it has to have capacity to make a will. That's really difficult to prove in the will. That's why another reason why working with an expert, we're going to have file notes and be able to say, we have evidence that this person had capacity at the time of writing it. So that's a key element of it being valid, that you're not going to spot on the paper. It needs to revoke all former wills. So typically the first line will say, I, Lucy Percy, revoke all former wills made by me. And we could say in Australia or across the world, there's lots of nuance there if you have assets in another jurisdiction. I did have a matter where it was actually a lawyer who had forgotten the revocation clause, $20,000 to go to court and say, actually, here's the latest will, but it didn't revoke this earlier will. Dear court,
Oh, wow.
what do you think we should do? The outcomes are just catastrophic when you miss a word or two. Revocation. And then the next typical thing is that the will appoints an executor. The will, if it doesn't do that, like if it's a DIY, again, we'd just go back to the principles under intestacy and there'd be an administrator, but then the gifts in the will that didn't fail would still work. So an executor we've talked about, and for me, I like to have lots of contingencies and we're really deliberate. If this happens, then that happens. They might be executors after this date, but not on this date, or conditional upon them living in Australia or not, because there's lots of tax reasons why we want at least one Australian resident executor. My will then goes into gifting of personal belongings or specific gifts. So is there a cash sum we want to leave? Do we want to gift the executors something for acting? I'm really in favour of that.
Because executors can charge the estate for discharging their duties, can't they?
Well, there's three ways an executor might get paid. So one, and what I favour, is a specific gift. I like to give specific gifts if there's enough money there. I think it motivates executors to work quickly and efficiently. Nothing is worse than an estate where the executor's dragging the chain. And they're a little bit accountable. If you've been paid for this, stop and take the time off work you need to and get the job done. So specific gifts, they can apply to the court for commission if there is no gift in the will, or with the consent of beneficiaries. So commission is a percent of what the value of the estate was. I definitely steer clear of that. That is often what the trustee companies do. So they might have a really high commission, and that's how they can afford to do cheap wills. And then the third is hourly rate. So, they record their time and they put in a bill. But then, all of these need a specific clause in the will to do that, except the commission. That's in the legislation. But it's not always easy I wouldn't rely on it. That's just time, cost, complexity. Yeah.
So the will needs to nominate the executor, revoke all former wills. What else has to be in a will for it to be valid?
Yeah, it needs to gift the residue. So there's lots of great case law. There's a wonderful case where a man went and saw a really expensive lawyer. He had 6 children, I think, and over 10 mil, between 10 and 20 mil, and he must have got sick of paying the legal fees. So he took the draft that the lawyer had done and he finished it himself. And this clever man successfully set up 6 testamentary trusts. He got the revocation done. He did a great job. He didn't gift anything into those trusts. He just forgot to gift the residue. So I'm going to say that's where the heart of your will is, who's getting the residue. If that fails, then we go back to the intestacy and we look at that chart and it's like this person gets this amount, this person gets this amount. Yeah.
You mentioned something there, and again, in an upcoming episode, we'll go into more detail, but can you quickly run through what a testamentary trust is, please?
Yeah. A trust is, instead of gifting something to a human being outright, we are going to skip the human being and we're going to pop it into a trust. The word testamentary means that it can only be created by a testator, a will maker, in their will. So it's actually identical to a family trust that people would be really familiar with, but it can only be created by a will. The assets come from the deceased only, so we don't intermingle assets after the fact, and it only becomes enlivened when the will maker dies. So one of the reasons we might do that is that instead of my dad leaving me $1 million inheritance, he could put it in a testamentary trust and then I can stream the income to my children, get some great tax benefits. If I get sued in my job, the inheritance dad's left me is safe in a testamentary trust. Typically family law is also another area where they can add value. They're not watertight, but can add a lot of value in family law as well. Yeah.
And I think where we've seen them used really well for clients is when they want to leave money to kids that are 15 to 17. And I know if you left me $1 million
Yeah.
when I was 17, I'm not going to
Yes.
have $1 million when I'm 18, I don't think.
Yes. Can I actually say, even if people think, and again, this is a general law firm, might get this wrong, I gift 50% of my estate to my child upon them turning 25, or I'm
Mm.
going to give 10% when they're 21, 30% when they're 25, 30% when they're 28, and the remaining 10% when they're, I don't know, is that something, 30%
I lost track too.
when they're 30? That actually will fail. There is great case law that says that as a beneficiary can apply to the court and say, actually, I want the whole lot when I'm 18.
Mm.
So the only way to make sure your kids can't make that demand on the court is by using a testamentary trust. That is well-established case law. Yeah.
Yes, that's fascinating.
Mm.
Having seen a few wills, I have to say, and this is probably true of most legal documents, they're not the most readable thing. They're not the clearest
They're
document to read.
awful.
It's whatever language they're written in, it looks like English, but it's not quite the same. But these documents provide a great deal of clarity. So I'm curious, if I'm just an executor, how do I use that? Like, really, you need a lawyer to help you with it, don't you?
Yeah, that is a great question. The New South Wales and Victoria are increasing, and I think doing the services to help executors DIY, I think, is as good as it's ever been. I must admit, there are some wills and estates that are so straightforward that I split my deceased estate work up into two parts. So there's application for probate. And
Hmm.
then when we've got probate, I might say to you, you've got this. You're just going to call in the aged care bond, divide it by 4, get your accountant to do a nil tax return, and then you're done.
Hmm.
Do it yourself. Or there are others that I say, this is really complex and you're going to need to keep me on board for the administration phase, and here's my cost agreement for that. So, I will say, as long as you've had a lawyer give you advice about what's in the will and the steps to do, for some people, you really can DIY, and I definitely empower clients to do that where it's appropriate and simple enough and low risk, like siblings getting along, all that sort of thing.
And having good advice up front or through the process, presuming that you're a married couple or a couple that have been through the estate planning process together, you will have had that clarity by dealing with the expert of saying, here's what this
Mm.
clause actually means, here's what it will mean in action. So it should be a little bit more familiar. But one thing I
Mm.
just popped into mind, everybody in Australia thinks that there is a great big reading of the will around the lawyer's boardroom
Oh,
table where everybody acts shocked.
yes.
Does that happen in Australia?
No.
Mm.
So it's a great question. So I have a booking on my website that's like half an hour advice. And sometimes it's beneficiaries saying, I've been given a copy of the will and I can't see myself in there. Or I don't know what it means.
Mm.
And so we'll just read it together. And I'll charge for that, but that's an invaluable service. So instead of sitting back and being like, why isn't the executor telling me more? Or why isn't the estate lawyer explaining this to me? I say to these people, don't be offended. The estate lawyer is actually not meant to give you advice at all.
Mm.
So the estate lawyer is their client is the estate,
Yeah.
and they can't meet with you, beneficiary. So a reading of the will would be dangerous from a legal perspective. If I did a reading of the will and there's 6 beneficiaries and one of those beneficiaries then went on to make a claim, I would possibly have to stop acting because there's the perception or the possibility that I learned something about that beneficiary in that room, or I gave them advice and I've now got a conflict at law.
Mm.
So
So the
that's
lawyer's
why
not
you're
being
not
nasty.
invited.
The
We're
lawyer
not
is
being nasty.
the beneficiary is simply not their client. It'd be as if they were
Correct.
talking to a stranger on the street about the estate.
Correct. But even worse, if the beneficiary in the room said, I'm so upset, I should have got more than that because, or I've got it, I need the money because, or mum and dad promised me this, I now have information that if that beneficiary goes and sees a lawyer, I shouldn't have that information.
Mm,
So, and
mm.
I can't control what the beneficiary is going to say in that room. So I simply shouldn't meet with the beneficiary unless they've got their own lawyer present.
So it's not just the quirk of Australian versus American law. There
No.
is a really fundamental reason, and it's to
Yeah.
protect the interest of the estate. Um,
Yeah.
some of the mechanics around wills,
Mm.
once they're written, where do they get stored?
I love that you included this question. I saw it on your planning list because it is actually an enormous problem. There is no register. So probably the safest thing that you can do is the courts, the Supreme Court in each state does offer to store the will for you. As part of the probate process, every executor has to do a search of the court records and they say, yep, there's no other will stored here. Now, in practice, that is used very seldomly because I suppose it doesn't offer a practical solution to things like where do I store my power of attorney, you know? It only often, it's only part of a solution.
I was heading down the cynical path, thinking that, well, lawyers want them in their office so they can pick up the estate.
Yeah. Well, do you know, I mean, so yes, look, that is my preference. I want to store your will, but the only reason is, and you're right, lawyers used to put clauses in there that were unenforceable, but, you know, executors would follow them in good faith. I direct that the firm of Head and Heart Estate Planning is employed in the administration of my estate. They're not binding.
They're not binding. Let's just clarify. They're not binding.
They're not binding.
Okay,
and
cool.
I don't write them. I mean, people will come back to me if they want, and they won't if they don't want. That doesn't worry me. But I get from the law society that I'm in, so the local area, and back when I was in Melbourne, the same thing. I'm going to say at least 5 emails a week saying, does any other lawyer hold the will of XYZ, deceased on this date? The family's looking for the will. And it is so stressful. I just sit there and think, oh my goodness, like the family know mum or dad did a will, they don't know where it is, and it's so hard to find it. We used to do things like, so you can advertise, you can reach out to your law society, you can advertise in the paper. I see it on LinkedIn all the time, looking for a will. We used to do things like, okay, who was the last firm that did a discharge of the mortgage? You know, who had the title.
Wow.
So we do historical title searches and we're like, who are the other firms that this person worked with at any time in their life? That's going to be less effective going forward because we're location independent now. I can't assume, and we're specialising, so I can't assume that whoever did the conveyancing work did the basic will. So it is an enormous problem and it is something that I see all the time. So I do also, there have been 2 times where I have suspected that a beneficiary or an executor found it in the house, didn't like it and destroyed it. That is a criminal, that's a criminal offence, but I think it's, like the
burden of proof is pretty difficult to hit.
Correct. Yep. So it's, you know, I mean, and even if that's not true and I'm wrong on that assumption for those 2 matters that I had, what's not to say that it's not happening? Prove to me it's not happening.
Yeah, even if 1% of wills that's occurring, that's disastrous.
Or burns them. Yep. So if you're storing them at your house, I just think people don't realise. I think they think common sense will prevail and it'll be like, but I signed a copy, but someone will find it, or my lawyer's got a copy. No, we really need the original, and there's just no substitute. Like the court system is doing the best it can to modernise, but we have these overarching laws and accepted cases that just tell us that we just need the original.
You use the term common sense there. I'm starting to get the feeling that common sense is to estate law what fairness is to family law, which is everybody has their own interpretation of what it is. And they assume that everybody, because common sense, you cannot rely on that when it comes to this kind of thing. So what would best practice be? So I get my will done. It's all signed. It's witnessed. It's very, very perfect. What's best practice for storing that?
Well, I mean, I do offer to my clients to store it for them, and I do that, you know, no charge. It is actually at a significant cost to me. Like that's an overhead in my business. Yeah. It's a burden in terms of like responsibility, but also I store mine at a safe, secure place in Melbourne. So I pay a subscription, but I do that because I don't want any of my wills to be missing. So, you know, and I might change where I store them in the future, but any storage has a cost. And I mean, I just genuinely believe that. So the lawyer has legal responsibility to keep a deeding record. If something happens to the lawyer, if I sold my firm or I died, the law society is going to track where did Lucy's deeds go, or it should in theory. So I have had in the law journals in Victoria, we've tracked, okay, this firm closed in 1985, who took the deeds, then what happened after that. So if you're in the legal system, your lawyer has liability and obligations, and they should be doing the right thing. And if they don't, there's a question of negligence that
And that's not
might
the case with a post office will or an online provider.
no, or
That's
you
all on you.
storing it, or you storing at home. That's on you. So yeah, I suppose they're the two main options. If a client was storing at home, I would want to see a fireproof home safe. I think actually, technically, flooding is more common to damage wills than fire. So, something to think about. And you should also tell the lawyer where it is. And I say to my clients, if you're not sending them back to me, can I have a scanned copy? Like your iPhone will scan, so there's no excuse for not scanning, but at least then I've got a record of a signed copy. But it's not my preference. I just think they just get lost too often.
So best practice, keep the original with your lawyer, make sure their storage facility is secure, safe and consistent. Have a copy at home, somewhere stored safe with your lawyer's details on there, staple a business card to it or something like that. And let your executor know, A, that they'll be your executor, but also where the will is and who to speak with.
Correct. And I'm favouring it. I have a letter that's like, you've been included in this client's estate planning. If something happens to me, go to the New South Wales Law Society. Like if you can't find Lucy Percy, this is what you do. I used to post those, but now I'm more in favour of emailing because I feel like in 20 years' time, someone might be able to search the inbox. Whereas a piece of paper or a business card, I'm like, people are not holding on to that stuff.
It's funny the legacy thinking you need to do. Like, the document you write today needs to be active, could be active in 30 years.
Correct. Yeah.
So we'll hop into, because I'm conscious we've been talking for a while. It's been really good and enjoyable. But I do want to touch on beneficiaries. Specifically, what is a beneficiary and who can be one?
Yeah. It's a great question, actually. A beneficiary doesn't have to be a human being. It could be a trust, a company. That is not what's happening in day-to-day practice, but it is a charity. But it's someone who is going to receive a gift under your will. So it could be a gift like $100,000, or it could be a percentage of the residue, or a beneficiary could also have a right to something. So I give the rights to my intellectual property to this person, or I give a right to occupy my property to this person. But typically we're going to think about a beneficiary as being someone getting cash or a percentage under the will. We want to think very carefully about how we want to gift it to them. So outright, from human being to human being, or are we going to put it on a trust and they're a beneficiary of that trust? And we also need to think about, if that beneficiary dies, what do we then want to happen? And then what? And then what? So, yeah.
And I think on the estate side, I'll turn it around. On the superannuation side, there are restrictions around who can be the beneficiary of the payout from the super fund upon death. That doesn't apply so much on the estate side, does it?
No, there's no exclusions. Pets can't be beneficiaries. That is something I will say that we do get asked every now and then. They are personal belongings. They're property that you own. So no, your pets can't. But other than that, I haven't had anyone request a beneficiary and I've been like, no.
And do you have any guidance around kind of how people can go about choosing beneficiaries? Like, do you have...
It's a great question. Yes, that is something that I love doing. So, we can do something straightforward, like to my children in equal shares, to your spouse, to your partner. I suppose sometimes that's quite obvious. Actually, child-free couples or child-free people say, oh, my will's going to be so simple, I don't have children. It's actually the opposite. When you've got a spouse or children, it's kind of simple and the first two layers are done for us. Child-free clients, we think really deeply about what's the legacy you want to leave, who would benefit from it the most. Yes, you want to give it to your friend who's having a hard time. If they die, should it go to their spouse, to their children? Or no, does it stop there with your friend and then it goes to a charity instead? Or, I divide my estate in this way if I'm survived by Nick, but if I'm not survived by Nick, actually give Nick's children 200 grand and then the residue goes this way. Like, we just do so much, if this, then that. And I say to people, it's a lot of questions. And I say, yeah, but we're just methodical. We just pick through them one by one. And it might seem overwhelming, but actually if we just make one decision at a time, you'll get to the end and you'll be like, wow, I've done like 3 layers, or I've got 3 generations or contingencies done. Yeah.
Yeah, it's defining that path, and then, the experts just document it and make sure that it happens the way you want it to. But until we know what you want to do, we can't really do that. One thing that I think a lot of people fear or worry about, or may have even been through, people listening to this, what happens when you're unhappy with your allocation or what the will maker has left you in their will? I mean, this is a big topic, so we can just touch on it.
Yeah, well, this is like a to be continued. But so there's really two elements to a claim on an estate or a claim against a will. The first, I would say, is about someone saying the will is invalid. So the testator didn't have capacity, or there's a construction issue. So the gifting in the will is not clear. What did they mean? Or, they've done something in the drafting that's not quite right. Or, it's been amended, or there's hand notes on it, or something like that. So that's, is the will valid, is one whole area of contested estates. Then when we've got a valid will, or we all agree the will is valid, then the next element of a contested estate is I would like more provision. So I've been left nothing and I would like something, or I've been left something, but it is not what I was promised. I was promised something else and I acted on this promise in my lifetime. Or it's just simply not enough for the situation I'm in now.
Yeah, okay. So, and that we will have, I think we have 2 episodes coming up around disputes.
Awesome.
One on the collaborative piece, so trying to work together across the different parties, and the other one on a less collaborative, more litigated aspect. So they'll be coming out shortly as well.
You've got Harvey Specter coming in, do you? Harvey and Zinta.
As long as, I don't know, I probably shouldn't call them toe cutters, but yeah,
I'm
it's very
that day.
I mean, we make light because we've seen how awful it can get.
It's actually not funny, is it?
No. But Lucy, I think that's covered so much of the gamut of estate planning. It is such a big topic, and I think to emphasize that point of that sort of spectrum of quality, I don't know if you can say, but I can say, get an expert to do it. Don't do it yourself. Certainly don't leave it up to the Intestacy Act or the intestacy rules. And, I would stay away from a generalist too. Get an expert, invest the money in that process and have that certainty for you and the people you're leaving behind. Lucy, did you have any sort of final comments before we wrap up?
Yeah, well, just building on that point, if listening to this episode wasn't enough for you to identify that you need to invest in an expert, have a free call with any of the expert. There are so many sole practitioners or big firms who do estate planning well. Have a free call. The reason why you in particular shouldn't do a basic will is going to be fact specific. So what are the facts? What is happening in your life? How do you own your assets? Tell the person, and then they're going to tell you back, wow, I'm so glad you came to me, because if you did this wrong, there'd be this really bad outcome. So let us tell you why you should spend your money on it. Does that make sense?
Absolutely. And I think another topic we'll look to cover down the track is, again, the people that are listening may have inherited a pot of money and it's in a very complex structure, and there's your facts will be different to the next person's facts, and definitely seek out that expert advice. Lucy, if people have further questions for you or they wanted to have a chat with you, where's the best place to find you?
Yeah, on Instagram, or email me at lucy@hhep.com.au. I will most likely send you a link to book a call. The link is also on my website, but sometimes I check that you're in the right state for me and all those sorts of things. Yeah.
Wonderful. Well, Lucy, thank you so much for that. Thank you for providing all that information. And if anybody's listening has any questions, reach out to Lucy. Thanks a lot.
Thank you.